Thank you, Richard, for those warm remarks, which has to be taken in the context of the excessive generosity of a good friend. I'm delighted to be here, and not by way of reciprocity. I want to commend Richard for organizing this very timely and compelling conference. I suspect that when Richard, and it's very much a family affair, his wife and daughters are all engaged along with his associates. I suspect when they went about to conceive of the conference, they did not have in mind that we would be meeting at a time when terrorist rockets would be targeting Israeli civilian populations. And Richard, I heard from my own daughter yesterday, you know, when you're told that your grandchildren are sitting in bomb shelters, it brings it home in a way that nothing else can, the inhumanity of the assaults on Israel. At the same time, the whole conference, while taking place at the same time as the terror attacks, also dovetail with what I would call an underlying theme of this conference, and certainly a theme of my remarks today, and that is the whole phenomenon of delegitimization. You know, if one thinks about it, one looks back, that it was the terror onslaught from 2000 to 2002, so expertly described by Ambassador Durban, which led to the establishment of the, and Richard describes it so perfectly, as the terror prevention security defense in his book on the Hague Odyssey, which I commend to all of you. It'll also allow me to just skip a lot of things and just reference the book, which in its essentials covers these themes so well. And in particular, what one saw there, and one sees in the Hague Odyssey, is that the erection of the terror prevention security fence led to the advisory opinion of the International Court of Justice, and was yet another case study in the phenomenon of not so much delegitimization, but the laundering of delegitimization, the masking of it, as it were, under the rule of law, under international judicial authority and the like. Which probably led me to say at the time, in 2004, I happened to have been a Minister of Justice in Canada, not only to critique the advisory opinion itself, but to say at the time that the court did not have jurisdiction to begin with. All of this put forth and as I say, compellingly described by Richard. And if we think to several years after that, when we had again, the terror assaults from Gaza, not unlike what we're experiencing now in 2009. That led to, if we recall, the infamous Goldstone Report. Yet again, another case study, what I would call the laundering of delegitimization. In this instance, under the culture of human rights. Let us not forget that Goldstone was not just something that was contrived out of thin air. The Goldstone Report was the outcome of a prejudicial mandate by the UN Human Rights Council, itself responsible as a kind of repository for international human rights law standard setting, and which predetermined the outcome of the Goldstone Report in its very terms of reference, establishing the Goldstone Commission. So all this evinces as well that which Ambassador Durban so effectively referred to as the reversal of causality. And this brings me to my particular theme today, because I suspect that at this point, it's not surprising that delegitimization has become a buzzword to denote today the assault on Israel's legitimacy, if not its right to exist, and always, of course, its right to defend itself. And that has spawned a veritable conference industry on this topic. It's hard to go anywhere today without seeing a conference on delegitimization. But very often, these conferences are taking place amongst ourselves. I have to tell you that amongst my colleagues in Parliament, delegitimization is not a common buzzword of discourse. It is something that when we say it, we know exactly what we mean by it. But to those who we need to convey it, they don't speak that same kind of language, not because they begin with some sort of inimical approach to Israel's, its rights, its legitimacy, but simply this is not the Weltanschauung in which they live. And I always say that the test for us is how do we make the case to the non-Jewish at university? How do we make the case, and in my instance, to my fellow parliamentarians or academics or jurists and the like? Because that's where the battle regarding delegitimization is being acted out. And the concern that I have at this point is not the phenomenon of delegitimization itself. It's what I call the laundering or masking of delegitimization under the universal public values. The masking of it under the protective cover of the United Nations, or the authority of international law, or the culture of human rights, or the struggle against racism, or the combating of genocide, in respect of which the inversion of causality that Ambassador Dermer spoke of takes place in each of these matters. But where, for purposes of the laundering of delegitimization, can be summed up by saying the attempt to portray Israel as the enemy of all that is good and the repository of all that is evil. And if you can succeed in that kind of characterization through the laundering of delegitimization, then you can impugn not only Israel's right to defend itself, so that when it defends itself it's portrayed as an international outlaw, but even begin to impugn its legitimacy, if not in fact its right to exist. But I want to say that despite all the attention that delegitimization has enjoyed now for the last decade, delegitimization is not a new phenomenon. In effect, delegitimization has always been with us. It was concurrent with the establishment of the state of Israel itself, when Israel was spoken of at the time as an original sin. It found expression in the run-up to the Six-Day War, and I remember then being a student at the Hebrew University of Jerusalem at that time before and during the war. But I still remember at the time when Israel was spoken of as a congenital act of aggression. Not what Israel did was the problem, but the very fact that Israel existed. But these were very blatant attacks on Israel's legitimacy. And therefore, they were more easily dismissible. Because, as I say, if you refer to Israel as a congenital act of aggression, then it's easily dismissible. The laundering of delegitimization began, in effect, with the Zionism as Racism resolution in 1975, which the late Senator Daniel Moynihan summed up the phenomenon of laundering, not just delegitimization, of laundering, by saying that the Zionism as Racism resolution gave the abomination of anti-Semitism, as he put it, the appearance of international legal sanction. And we have gone a long way since the Zionism is Racism resolution, both in the nature of the assaults and in the laundering of that assault. But something else was going on at the same time at the Zionism as Racism resolution, which we were all engaged in. But something else was going on which we were not taking notice of at the time. And I'm speaking here of the parallel, in 1975, of the parallel development of the international human rights revolution, of which the Helsinki Final Act was a case study. And yes, we invoked that in the struggle for Soviet Jewry, and the whole International Bill of Rights at the time, which led Father Robert Drinan, a former U.S. congressman and an icon of the struggle for Soviet Jewry, to say something that we may not have been paying enough attention to at the time, when he said that the elevation of human rights into an international juridical norm is the most dramatic development in contemporary jurisprudence. Now, I have to say that as a law professor and human rights lawyer in the mid-70s, I found myself living in two universes. One universe, of course, was the law, human rights universe, which Jews were living in as well, but mainly, almost wholly, with respect to the struggle for Soviet Jewry at the time. The other universe that was going on was the obverse side of that human rights revolution, today spoken of as lawfare, which I would refer to more broadly as the laundering of delegitimization, which was taking place, frankly, under the radar screen. Let me just give you a quick snapshot of what was happening in 1975, at the same time as the Zionism is Racism resolution, where the delegitimizers, if I can use that term, were invoking the whole of universal public values, protective cover of the UN, human rights, international law, and the like, for the purposes of the laundering of delegitimization. And so it was, and I'm going to use only one case study, and that is the work of the UN specialized agencies at the time. And so it was then that Israel was held out to be the enemy of labor. Evidence? I can say alleged, but that's not evidence. The resolution of the International Labor Organization at the time and since, condemning Israeli suppression of trade unionism. The enemy of health. Evidence? The resolution of the World Health Organization at the time, condemning alleged Israeli poisonings of Palestinians on the West Bank. The enemy of culture. Evidence? The resolution of UNESCO, condemning Israeli desecration of historic sites in East Jerusalem and West Bank and the like. The enemy of women. Evidence? The resolution of the UN Commission on the Rights of Women, condemning Israeli violations of women's rights. The enemy of human rights. Evidence? The resolution of the UN Commission on Human Rights at the time, the predecessor to the UN Council on Human Rights, condemning mass Israeli violations of the human rights of Palestinians. And the enemy of peace. Evidence? The resolution of the United Nations General Assembly condemning Israel as a non-peace-loving nation. And so it was then that Israel was held up at one and the same time in 1975, when we weren't paying attention, and not only in the UN specialized agencies, I'm giving this only as a case study, as the enemy of trade unionism, health, culture, women's rights, human rights, and peace. In a word, Israel was held out to be the enemy of all that is good and the repository of all that is evil. As I wrote some 35 years ago, that in a world in which human rights has emerged as the new secular religion of our time, the portrayal of Israel as a meta-human rights violator, as the enemy of all that is good, meant that Israel was in effect the geopolitical antichrist of our time. And so what I would like to do now, just in the balance of my remarks, very briefly address three things. Number one, how is it that we got to this place now? I mean, why is delegitimization something which is the buzzword of discourse now, when in effect it was happening then? As I say, we weren't paying attention to it then. Two, what are some very clear case studies of the laundering of that delegitimization? And finally, what is it that we must do? Let me begin first with how we got to where we are. I want to suggest to you that there are a cluster of dynamics that give context and content to the development of the critical mass of delegitimization. Cluster these dynamics in very almost crude, abbreviated one-liners, but this is an audience that needs no elaboration. The first thing was globalization. Globalization not only of media and markets, not only of trade and technology, but the globalization of law, of human rights, of NGOs. That was a good thing. That's the positive side of lawfare, if you want to say L-A-W-F-A-I-R. But there was the darker side of lawfare that we were not appreciating, and that was the developing dynamics of the laundering of delegitimization, among others, under the cover of law. The second thing was the and we weren't paying much attention to this as well, but it was happening, and of course now when I say it, you say, of course. But at the time, and one has to be anticipatory and preemptive, rather than being dilatory and reactive when it's after the fact and you're playing catch. At the time, we saw the reconfiguration of the Arab-Israeli conflict as the Israeli-Palestinian conflict. And as my colleague said to me at the time, in 1975, my late and brilliant colleague, Justice Walter Tarnopolsky of the Ontario Court of Appeal, put it very well. He said, as long as the Arabs have said that Israel has no right to exist, they have no case and no standing to make the case. But if it begins to appear that Israel is challenging or denying the Palestinian right to self-determination, then Israel will appear not only to have no case, but no standing to make the case. Now, this is in 1975. We're talking about something 40 years ago, in effect. But these were the developing dynamics. The third thing was the conversion of the Israeli-Palestinian conflict, narrative into a human rights issue, where the Palestinian case became the poster case for human rights, and Israel became the antithesis, as it were, within that Israeli-Palestinian configuration of the human rights case and cause. The fourth was the mainstreaming of that Palestinian human rights case and cause amongst all the eight elites. You know that. Diplomatic, parliamentarian, academic, media, church groups, and the like. Such that, for one case study, on the campuses where Palestinianism became the poster child for the human rights case and cause, broadly speaking, in a culture, the campus culture, and I lived in that campus culture, really was one of a culture of human rights itself, with all the cases and causes thereby emanating and developing. Then you had, of course, and it's not a new phenomenon, you had the development of the boycott, divestment, sanctions movement, which became as well part of not only the Palestinization of human rights, but also the manner in which the Israeli apartheid week phenomenon developed. Then you had the denouement of the Soviet Jewry struggle, which, while we were rightly preoccupied with it for those 20 years, from 1970s into the 90s, we were missing that other darker side of the laundering of human rights that was taking place. But we had also the asset geopolitical advantage of the East-West configuration. That too went with the denouement of that struggle. And then finally, we had Durban. Now, Durban is spoken of very often as the beginning of the delegitimization. Durban was not the beginning. Durban was the culmination. Durban did not invent delegitimization. Durban codified it. And I happened to be there at the time at Durban, and I'll never forget just one dramatic vignette amongst the many. And that was the marches that were taking place in the streets of Durban with the daily chant that the struggle against racism in the 20th century required the dismantling of South Africa as an apartheid state, and the struggle against racism in the 21st century requires the dismantling of Israel as an apartheid state. This was, as I say, the culmination of the dynamics of the laundering of delegitimization, not the beginning of it. Now let me just go to my second theme very quickly, that is the case studies of the laundering of delegitimization. Very quickly, 4 case studies. Let me begin first with the protected the laundering of delegitimization under the protective cover of the UN. I know that in the Israeli political culture, we all know the conventional wisdom of Shmum, and I know that the suspect approach with which the UN is understandably approached here in the United States. In other cultures, in Canada, the UN is almost like part of our DNA, like something that can do no wrong. And that is true in Europe and also. So we have to think of this, when I talk about the laundering of delegitimization and the protective cover of the UN, that the UN still is in the DNA of much of the global culture, political culture. And the Jews were very much present at the creation with respect to the UN, and were very much part of that initial thrust of the internationalization of human rights through the UN. That's part of what we should be doing, rather than dismissing the UN, being at the forefront of reforming the UN, not for the sake of the State of Israel, but for the sake of the integrity of the UN, whose followed would be countering the dynamics of delegitimization. But let me here give you just one case study of the laundering of delegitimization on the protective cover of the UN. I'm referring to the annual ritual of some 20 to 22 condemnations by the UN General Assembly of Israel. Not only more condemnations than of any other country, but there are only some 4 other similar condemnations at all in a UN General Assembly that meets over 3 months. Now, as someone who is a member of the Canadian delegation to the UN, the problem is not only, though, certainly that, the critical mass of delegitimization through 20 to 22 resolutions. It is the process of that delegitimization over 3 months, when people who are members of those delegations, like I am, are not only diplomats, but they're parliamentarians, they're academics, they're journalists, they're church leaders, they're students, and the like. They internalize that critical mass of delegitimization. And so the laundering then becomes part of what the French would call sensibilisation, whereby it becomes part, and most people come to the UN like tabula rasa. They come there with, no real pre-knowledge, and therefore are exposed to that critical mass of delegitimization. And I want to say to you, it's not, when you look at these resolutions, they all read like legal judgments, alleged findings of fact and conclusions of law. And it's not surprising that the main focus for some time now has been on the illegality of Israeli settlements. Let's face it, the US political culture, the Canadian political culture, the Western, we are legal cultures. If you say something is illegal, it's much worse than saying it's stupid or ill-advised or wrong. If you repeat it again and again and frame it within the alleged authority of a UN General Assembly resolution, which then is passed on, etc., then you see how the laundering of delegitimization takes place. And it reminds me of something that was said to me 40 years ago by Osama al-Baz, then the principal advisor to Sadat, and then after to Mubarak. And he said, as soon as Begin became Prime Minister of Israel, he said, if Begin continues to say, if we have no right to Hebron, we will have no right to Tel Aviv, he said, we will show the world that Israel has no right to Hebron, and then the world will realize that Israel has no right to Tel Aviv. And so this focus on the illegality of the settlements has corrosive followed within a legal culture and within the laundering of delegitimization. The second is the laundering of delegitimization under the authority of international law. I'm very tempted to say, just read Richard Heidemann's book and you'll see this. And not only tempted to say, I'm saying that is the way to really see it in all its manifestations, because really on this second point, the laundering of delegitimization under the authority of international, under the rule of law, you can write a book about it. It isn't only an op-ed and the like. But let me take you just one example, and that is the principle of universal jurisdiction. The principle of universal jurisdiction says that whenever you have a situation of war crimes and crimes against humanity, let alone, God forbid, genocide, that every state has the authority with respect to the prosecution of that war criminal. That was the legal basis for Israel prosecuting Adolf Eichmann at that time, and they invoked in Israel the principle of universal jurisdiction. Well, what has happened now is that principle of universal jurisdiction has been turned on its head, and Israeli nationals are singled out in such a way that Israeli ministers have to refrain from travel to countries in Europe, and more recently again in the UK, lest an arrest warrant be issued for their arrest for alleged war crimes under the principle of universal jurisdiction. In other words, the selective singling out of Israel for prejudicial and discriminatory treatment under the rubric of international law. The third is the culture of human rights. Again, chapter and verse, UN Council of Human Rights. I'll just give one example. One example. As someone who was present there at the UN Council of Human Rights, and witnessed for myself that every session of the UN Council of Human Rights begins with an agenda item 7 that singles out Israel for condemnation even before the hearing begins. A kind of Alice in Wonderland situation whereby both the conviction and the sentence are passed. An example of that, of course, is agenda item 7, sometimes it's 8, which speaks about Israeli human rights violations in the occupied Palestinian territory, not a matter to be determined, but as a statement of a finding of fact and conclusion of law. And the next agenda item, sometimes 8 or 9, is human rights violations in the rest of the world. And this goes on at every meeting of the UN Human Rights Council. The final one is the laundering of delegitimization under the struggle against racism. Let's face it, one of the worst things you can do in the world today, or at any time, is to call somebody a racist. The very label supplies the indictment. No further proof is required. And if any further, and that's what led to Moynihan's remarks redesigned as those racist rules. But if any further proof is required, what you do today is you label Israel as an apartheid state. And this condemnation of Israel as an apartheid state is not just happenstance. For those who invoke that kind of indictment know very well that apartheid is defined under international law as a crime against humanity. So if you say that Israel is an apartheid state, what you are saying is that it's a crime against humanity. If it's a crime against humanity, it has no right to be. If it's a crime against humanity, its supporters are criminal accomplices in this criminal enterprise. And therefore, they should not even have any right to speech because their speech is criminal speech and so on. And if any further indictment is needed or further proof is needed, then you say that Israel is not only an apartheid state, you say that it's a Nazi state. If it's a Nazi state, it not only has no right to be, but there is an obligation, even in international law, to make sure that it has no right to be. And so the laundering of delegitimization with respect to the indictment of Israel as both an apartheid and a Nazi state is not an accidental phenomenon. And it is a way not only of denying Israel's legitimacy, its right to exist, its right to defend, but also to silence its supporters, to make of them also criminal accomplices in this criminal enterprise. And on the matter of the laundering of delegitimization under genocide, I'll just say one point here. And that is, Israel is the only country in the world today, and the Jewish people, the only people in the world today, that are standing targets of state sanctions, incitement to hate and genocide. Whether they proceed from a state like Iran, or whether they proceed from terrorist organizations like Hamas and Hezbollah, or whether they proceed from fatwas in mosques and the like. But the worst is not only that Israel is the standing target of such state-sanctioned incitement to hate and genocide, but that Israel is the only state, and the Jewish people are the only people that are also regularly accused themselves of having committed acts of genocide. And that's what happened in the previous incursions of Israel into Gaza. And let us not forget, because those kinds of allegations can begin to surface. Let me close very quickly with what we might do. The first thing I have to say is that time has come, really, it's very, very long past. It doesn't have to repeat it, but it still needs to be said. We have to get out of the docket of the accused and into the standing of plaintiff claimant, advocate, and the like. And not do so alone, but do so through networks, because you can only combat delegitimization through networks, and not only networks of Jews, but combating delegitimization while working with human rights networks. Don't just dismiss the whole human rights movement as the adversary of the Jewish people. There are a lot of good people out there working in human rights. We have to engage with them and mobilize with them. The second thing is that we have to invert that prejudicial paradigm which says that the Israeli-Palestinian conflict is the source of all conflict in the Middle East, the occupation is the source of the Israeli-Palestinian conflict, and apartheid Israel is the source of the occupation. We have to really, for some time, just turn that paradigm around. The source of conflict, not only the Israeli, but conflict in the Middle East itself, is both radical Islam and Arab tyrannies. Much of what is happening in the Middle East and the killing today, I don't have to go into chapter, has nothing to do with Israel today, whether we're talking about Iraq or we're talking about Syria and the like. The second thing is that what we find with respect to radical Islam and Arab tyrannies is an ongoing denial of Israel's right to exist to begin with. This is the real apartheid. The refusal to allow a Jewish state to exist in any borders. And the final thing is, it's not only a denial of Israel's right to exist, it's a public call for the destruction of Israel and the killing of the Jews wherever they may be, not as happenstance, but anchored, in fact, in the Hamas covenant, which is a case study, if you will, of genocidal anti-Semitism. These are not words that I would use lightly or easily, but there are no other words to describe the toxic convergence of the advocacy of the most horrific of crimes, namely genocide, embedded in the most enduring of hatreds, namely anti-Semitism, and anchored in what in effect is a kind of constitutional covenant of Hamas. The third thing, and this is what Ambassador Durban was talking about in terms of the reversal of causality. Let me just take the Arab refugee thing. I'll try to do this very, very quickly, but just as a case study of what I'm referring to here. Some years ago, I was invited to speak to a group of lawyers, all non-Jewish, on the question of the Genocide Convention, as it was at the time, 60 years later. What have we learned? What must we do? And I gave some 6 lessons of the Genocide Convention, let's say, in the last 60 years, etc. And then I sat down. A woman then got up, a lawyer, and she said, Professor Cotler, you know that I'm a lawyer. I was a lawyer in the Department of Justice when you were the minister. It's something that some of us always wanted to ask you, and we never had the chance. You spoke today of the 6 great lessons of the Genocide Convention, but you didn't mention a word about the Palestinian suffering. You didn't mention a word about the Palestinian Nakba, the catastrophe to the Palestinian people. Can you tell us why you didn't say anything about Palestinian suffering, the Palestinian Nakba? And I felt, and I said, you know, you're right. The Palestinians have suffered, and they continue to suffer. You're right. The Palestinians have suffered a Nakba, a catastrophe. I said, but what happened 60 years ago in 1947? I said, we had the then UN partition resolution, which mandated the partition of then mandatory Palestine into 2 states, a Jewish state and an Arab state. I said the Jewish leadership at the time accepted the resolution, the Arab and Palestinian leadership did not. I said, mind you, they had a right not to accept the resolution if they felt it didn't comport with their interests. But what they didn't have a right to do was to then launch a war of aggression against the nascent Jewish state, which they spoke of, not me, which they spoke of as a war of extermination at the time. What they didn't have a right to do was to then turn on their Jewish nationals living in Arab and Muslim lands, disenfranchising them of their citizenship, stripping them of their rights, dispossessing them of their assets, arresting them, detaining them, torturing them, expelling them. So as a result of these 2 acts of aggression against the nascent state of Israel and against Jewish nationals in Arab lands, we had 2 sets of refugees, Palestinian Arab refugees and Jewish refugees from Arab countries. I said, it's a tragedy to think that if the Arab and Palestinian leadership had accepted the UN partition resolution at the time, we today would be celebrating the 60th, let's say 66th anniversary today of 2 states for 2 peoples. And I sat down. And she got up, and this is why I'm telling this story. She said, do you mind if I say something? I said, no, please go ahead. She said, I have to tell you, I consider myself a reasonably well-informed woman. I'm very active in public affairs. This is the first I've ever heard about Jewish refugees from Arab countries. I want to tell you, don't think of where we sit and from where we come. Whom do we have to speak to and influence where they are coming from? And then she added, of course, I knew about Palestinian Arab refugees. I always thought that this resulted from Jewish ethnic cleansing of the Palestinian people. She said, I'm pleased to hear what you have to say. I guess as a lawyer I'm going to have to go back and learn, and if I can begin to understand it, she said, it appears to me that there was not only a Nakba to the Palestinians, there was a Nakba to the Jews, and then she used the phrase, there was a double Nakba. And as a lawyer, we have to appreciate who is responsible for the double Nakba. And she sat down. And that's why I closed by saying that when we want to make the case against delegitimization, particularly the laundering of that delegitimization, don't make it in terms of the fact that it's prejudicial to Israel or it's prejudicial to the Jewish people. Make it in terms of the fact of what people out there to whom you need to make the case care about. Tell them that it's prejudicial to the integrity of the UN. That if they care about the UN, they should care about the laundering and delegitimization under the protective cover of the UN. Tell them it's prejudicial to the authority of international law. That if they care about the rule of law, and they care about the authority of international law, they should care about the usurpation of international law in this prejudicial sense. Tell them that this corrupts the culture of human rights, and that if they care about human rights, then they have to care about this corruptive application of human rights, and tell them that it corrupts the struggle against racism, and even in its most profound sense, in terms of the struggle against the real apartheid. It shames the real apartheid, and it corrupts the struggle against the real genocide, and the real killing fields, wherever they may be happening today in Africa, in the Middle East. Make the case in terms of where people are, not in terms of where we are now, and not in terms of where we want them to be, because they're not there yet. Engage them, make the case, inhabit their psyche. We have a powerful, compelling case. And I believe, to use the expression at the end of the day, Netzach Yisrael lo yishaker, justice will prevail. Thank you.